Welcome to the debate. Usually a bank ledger is viewed as the ultimate source of objective truth. It's a precise map of human activity, every cent tracked, every transfer illuminated.
Right. It's supposed to be entirely transparent. The numbers are either black or red. The transaction either happened or it didn't.
Exactly. But when you step into the intersection of global finance and, well, human trafficking, that ledger suddenly becomes an incredibly opaque document.
Yeah, it really does.
We're looking at a financial landscape where the numbers don't just record transactions. They tell a story about who we protect and ultimately who we ignore.
And honestly, nothing illustrates this tension better than Bank of America's recent agreement to settle the civil lawsuit, the one brought by Jane Doe on behalf of Jeffrey Epstein's accusers.
Right, which was a huge development.
Massive. And the central question we're looking at today is whether this settlement, which crucially cancels a highly anticipated public May 11th trial, actually holds the financial institution accountable. Or, is it essentially just a defensive maneuver to hide systemic failures from public scrutiny?
And to set the stage, we're looking closely at the recent filings presented to Manhattan federal judge Jed Rakoff. He previously ruled that Bank of America couldn't just brush this off. They had to face claims of knowingly profiting from sex trafficking.
Which was a major turning point.
It was. And from my perspective, forcing a bank of this size to settle, especially on the heels of other massive banking payouts, enforces unprecedented legal consequences. It delivers tangible justice to the victims.
Well, and I'll be arguing the opposite today. Settling out of court actually denies us full transparency. It essentially functions as a highly capitalized corporate shield, allowing the bank to maintain its innocence on paper and basically bury the actual mechanics of what happened.
I hear that, but think about how banks have operated for decades. They've had almost total impunity regarding the downstream effects of their clients' actions. But here, the legal system successfully cornered the second largest bank in the United States.
True, they did corner them, but
Judge Rakoff ruled that Bank of America could be held liable under the Trafficking Victims Protection Act. And let's clarify what that actually means, right? The TVPA isn't just about the traffickers themselves.
right, it extends much further.
Exactly. It means if a bank sees glaring red flags like a multitude of highly suspicious, unexplained withdrawals and chooses to look the other way just to keep a wealthy client, they are legally complicit.
But look at the bank's official posture right now. They are still maintaining that they merely provided, quote, ordinary banking services to individuals who had no known ties to Epstein at the time.
Sure, but that's just PR.
Well, they are officially calling the claims of deeper involvement without substance. And you might be listening to this and thinking, well, the victims are getting financial relief. Isn't that a win?
It absolutely is a win.
Yes, financially. And I don't want to diminish that relief at all. But legally, because the settlement cancels the impending public trial, it also cancels the March 26 sworn deposition of billionaire Leon Black.
Ah, the Leon Black deposition.
Right. This is a man whose own external reviews showed he paid Epstein $158 million for quote-unquote tax advice. By shutting down that deposition, the settlement prevents the global banking sector from facing the bright light of a public reckoning.
I see why you think that, but let me give you a different perspective. How can you deny the severe legal consequences here when a federal judge explicitly ruled Bank of America must answer for obstructing the Trafficking Victims Protection Act?
Because they aren't actually answering for it in court now.
But doesn't the sheer legal pressure that forced this settlement prove that the ordinary banking defense is no longer a viable shield? They had to settle.
I come at it from a different way. Acknowledging Rakoff's initial ruling is important, sure, but a settlement prevents that ruling from ever being tested and solidified in a May 11th trial.
You don't think the settlement itself is binding enough?
In our system, binding precedent requires actual case law. Without a public verdict, Bank of America avoids admitting any legal liability. They do not have to confess to obstructing the TVPA on the public record.
But they paid out.
Right, but instead of creating an unshakable legal standard that future courts can point to, the resolution is reduced to a financial transaction. They essentially bought their way out of precedent.
I have to disagree there. because that financial transaction has massive ripple effects across the entire industry.
Does it, though? Let me pose this to you. Let's look at the historical data. JP Morgan settled for $290 million in 2023. Deutsche Bank settled for $75 million.
Huge numbers.
Now, Bank of America is settling for an undisclosed amount. Are these settlements actually teaching the global banking sector a lesson? Or have these astronomical figures just become the calculated cost of doing business for turning a blind eye to high net worth clients?
They are absolutely teaching a lesson. You cannot separate those payouts from the behavioral shifts they trigger inside these institutions.
What kind of shifts?
Well, global banking compliance runs on algorithms. It is deeply, mechanically risk-averse. When you inject a $290 million loss, a $75 million loss, and now whatever this massive BOFA settlement is into those risk models, the code physically changes.
Wait, you're saying the software itself adapts?
Exactly! Transactions that used to be flagged as, low-risk ordinary banking are suddenly recalibrated to scream liability.
So it forces a technological shift.
Yes, and a human one. It forces compliance officers to scrutinize high-net-worth individuals, not just for standard money laundering, but for human rights abuses. It synthesizes these payouts into a strict, undeniable new risk management lesson for the entire global banking sector.
I hear the systemic argument, I do.
But let me turn this back to the human element, which we really can't lose sight of. The victim's attorney, Sigrid Macaulay, she called this a vital step toward long overdue justice.
She did.
Right. So if the plaintiff's own legal counsel publicly heralds this resolution as long overdue justice, isn't it patronizing to suggest that the victim's perception of this victory is somehow flawed just because we didn't get a public trial?
That's a compelling argument, but have you considered what was actually traded away here? I don't believe it's patronizing to demand full transparency. It's recognizing how accountability actually works.
But the victims got compensation.
And the financial compensation absolutely validates the victim's suffering. I am not denying that. But true justice requires sunlight. By canceling Leon Black's testimony regarding his $158 million payments, the settlement deprives the victims and the public of understanding exactly how the financial machinery facilitated the abuse.
You're focusing entirely on one deposition, though.
Because that deposition is the blueprint of the failure. How does $158 million move through a heavily regulated U.S. bank for purported tax advice without triggering a massive internal audit?
I mean, that is the question.
Right. We needed to see if there were executive overrides. We needed to see the deliberate blind eyes. The perception of justice remains fundamentally incomplete when the mechanics of the crime stay hidden in sealed document. We get to pay out, but we lose the blueprint.
Okay, but ultimately look at the progression we've seen. From the $290 million JP Morgan settlement to the $75 million Deutsche Bank settlement, leading right up to this Bank of America agreement. It demonstrates a powerful new legal reality.
A very expensive reality, yes.
But more than just expensive, global financial institutions are successfully being held liable for facilitating trafficking. This isn't just a penalty, it enforces strict new lessons on global banking compliance and delivers undeniable validation to victims who took on a deeply entrenched system.
And in my view remains that while these settlements provide vital financial restitution, they act as highly priced corporate confidentiality agreements.
A corporate shield, like you said earlier.
Exactly. By canceling critical under oath depositions, they allow banks to avoid public trials. They leave the ordinary banking services defense completely intact on paper, shielding the sector from the true public reckoning required to dismantle institutional failure.
We do, however, reach a crucial point of convergence here. We both agree that Judge Rakoff's willingness to even entertain claims against these institutions under the Trafficking Victims Protection Act marks a seismic shift.
Oh, absolutely. The justice system is fundamentally changing how it views banking compliance.
It really is.
And, this story isn't entirely closed. With the final settlement document due March 27th and the approval hearing set for April 2nd, there is still much to explore regarding the final, currently undisclosed terms of this agreement.
Which brings us back to that bank ledger we discussed at the start. Are these monumental settlements finally forcing the global banks to open their books to the light, creating a transparent accounting of human cost?
Or Are they just another incredibly expensive line item used to buy a new curtain, keeping the darkest transactions safely out of view?
That is the question we will leave you with today. Thanks for joining us.